Hello and welcome to the IP Australia podcast, and this is our series for small businesses and startups. My name's Lisa Cohen and I'm the Director of Public Education at IP Australia, and I really want to thank you for tuning into the program today. For those who might not be familiar with IP Australia, we're the Australian government agency responsible for administering IP rights. We administer patents, trademarks, design rights and plant breeders' rights, and our purpose is to enable Australians to benefit from great ideas. Before we dive into the episode, I'd like to acknowledge the traditional custodians of the land which I'm coming to you from, which is the Ngunnawal and Ngambri people in the ACT. So, in this episode, I'm joined by some fabulous and knowledgeable guests from IP Australia who will help us navigate and understand the complexities of IP, its protections, and help you start on your journey. So let's get started. And joining me on our exciting first episode are Nabil, Ilahee and Keeley Pasfield. Now, Nabil, you're the Director of Business Operations in the Patent Examination Group at IP Australia. And I know how passionate you are about education and learning. And you've got, quite a resume of looking at doing these activities across both academia and the public sector. And Keeley, you're an Assistant Director in the Public Education team. But you started your career with your own business, probably much like many of our listeners today. You were an exercise physiologist for track and field athletes before transitioning across to the public sector and working in intellectual property. And since you've been with us, you've held a few roles working in trademark examination training and customer experience. And look, I just want to welcome the two of you. I'm so delighted to have you here.
Thank you so much, Lisa. It's a pleasure to be here today.
Yeah, thanks so much for having me. I'm really excited to be part of the very first episode.
Let's dive straight in. What exactly is intellectual property?
Intellectual property, or what is often called IP, are creations of the mind. So anytime you think about something that you create that's new or original, you're often creating IP. If we look around us, there are chair designs, medical devices, mechanical devices, the style of the shoe that you're wearing, software and data sets that we see around us, brand names or logos, or even literary and artistic works. These can all relate to IP. Fortunately for us, Australia's IP laws provide that robust legal framework to protect your creative ideas through IP rights. So when you think about your business, your unique selling proposition or competitive advantage is what sets you apart from your competitors. If you are thinking about protecting this, controlling this, or keeping this unique element or idea to yourself, this is often what we refer to as IP.
Thanks so much, Nabil. Gosh, creations of the mind. It doesn't get much broader than that, does it? And we know how inventive Australians are and how innovative. And the really interesting thing there, I think, is that whatever the listener has as their idea, their unique selling proposition or their competitive advantage, the thing that sets you apart from your competitors, that is probably your intellectual property. And we've heard that many small business owners think that intellectual property rights or registered IP rights are only for large organisations. But Keeley, can you bust that myth for us perhaps?
Yeah, absolutely. I hear this so often and it's not quite true. Registered IP rights, like trademarks or patents, aren't just for big corporations. In fact, they can be incredibly valuable for small businesses too. So they protect that unique business aspect from being copied or misused by other people. And your intellectual property is an intangible asset for your business. So of course it should be part of your business strategy. For small businesses, IP rights help you to stand out in the market. So they give you that confidence to keep innovating and help your business grow. And they can actually enhance your business's value as well. So it's a lot more attractive to investors and potential buyers because it reduces that risk and also provides a level of security over what you've created. So I think it's really useful for small businesses to understand and utilise IP rights to protect their interests. It's really about protecting what you've built today and setting yourself up for future growth and opportunities.
Thanks, Keeley. They're wise words, actually. And I know that in our recent annual IP report, we can see research that shows that where a startup owns registered IP rights, they are actually valued at up to 20% more than startups without. And your words help us understand why, of course, because the intellectual property the business owns is then protected by the IP legislation. And we know that our listeners are probably interested in how other Australian businesses have managed their IP So do you have any suggestions on where our listener could find some insights about managing IP?
Yeah, so we have a lot of case studies on our website of small businesses that have successfully used IP rights, and that can be a multitude of different types of rights, and also an IP portfolio that incorporates different types. So I think, my faves, of course, have to be Soap de Villa. So they're a boutique soap maker. We have M Vision. So they've created a portable brain scanner.
Wow.
Which is amazing. That's revolutionising the treatment of stroke in regional and remote communities. And then we also have scoot boots. And as a horse girl myself, I love an innovative horse boot as an alternative to traditional metal horseshoes.
And I suppose they show the tangible benefits that IP rights can bring to business. And no one size fits all. And we haven't really talked about the different types of IP rights, and we'll get onto that. But it's so good to see diversity in those case studies. If you'd said to me 6 months ago, you're going to have case studies about horseshoes, brain scanners and soap, I'd have said, oh, how are we going to do that? So shout out to those businesses who have given us their time and allowed us to share their journey. One key question I'm sure our listeners will have if they're at the beginning of their IP journey is how can they actually identify if they have any IP?
I think it's important to recognize that first point, that identifying your IP is that important first step for any innovator or business. But when we go to the question of identifying your IP, we'll go back to what we talked about earlier in terms of identifying your unique selling proposition or the competitive advantage behind your idea. What's the reason that you stand out as a business? What stands you out from the market or the industry that you operate in? And this can often translate to different types and combinations of IP rights for different businesses. As Keeley earlier had mentioned, it's about making sure that you think of IP rights as a portfolio of IP. This is where tools such as choosing the right IP tool on our website can really help guide you in the right direction if you need help with this. Some of the examples to consider that might hopefully help people jog, their memory around what they're doing. If you think about an innovative product, service, or process that is new and useful, you might have a patentable invention. For example, like Wi-Fi or the cochlear implant. If you have developed a new plant variety that could be protected by a plant breeder's right, PBR, we often call it. We can often see them in fruits and vegetables, for example, that you see out in the market or when you go to the nursery. We also have case studies on our website covering a family business called Sprint Horticulture that uses PBRs to protect their ornamental plant varieties.
Wow. Again, the breadth of protection is amazing. Thanks, Nabil. So you can have IP rights to protect a product, a service, a process, a plant variety, even ornamental vegetables, if there's such a thing. One thing that I haven't mentioned there, I'm just wondering, our listeners, I'm sure, will be interested in, what about brand protection?
I might just jump in there, Lisa, actually.
Yep. Sorry, Keeley.
So if you have a brand name, logo or slogan, these are the types of things that can be protected with a registered trademark. And if we use Nike as an example, because that's a really well-known one, they have the brand name Nike. They also have the tick or that swoosh logo and the slogan, Just Do It. So there's lots of different elements there. And I guess another type of IP is a design right. So if you have designed the unique appearance of a product, this can be protected by a registered design right. And that could be a unique pattern or artistic design on a coffee cup or a T-shirt, or even, what your chair looks like in that sort of industrial design space. But I think it's really important with all of these just to touch on the fact that IP Australia administers the IP rights that require formal registration. So this includes registered trademarks, patents, design rights, and plant breeders' rights.
Thanks, Keeley. That's a great summary. I think there are other forms, though, of IP protection that I'd really like our listeners to know about, but IP Australia don't administer.
There are actually two very common types of IP rights that we don't administer, but are also very important for our listeners to know about. If you create original works of art, literature, music, films, or even podcasts like this one, these can often be protected by copyright. If you have created a new circuit layout in an electronic device, for example, this can be protected as a circuit layout. Now, with these two rights, it's important to recognize that these rights are automatically protected in Australia. So if someone wants to charge you to register your copyright, don't pay them.
Yeah, great tip. Listeners, if someone wants to charge you to register your copyright, don't pay them. So really important to understand that it's free and automatic in Australia, but not so everywhere else in the world. And an important opportunity, I think, to note that the IP legislation and system in Australia is unique to Australia, and each geography or jurisdiction internationally will have their own rules. And Keeley, I think you look like you're bursting to add something there.
Yeah, I just want to talk about one other option you have as well. So if you have business information that would benefit from confidentiality, like a manufacturing process, a recipe, your client lists, these are things that could be protected as trade secret. And if you want to have a think about the Colonel's Secret 11 Herbs and Spices, that's a great example. It's really important in a lot of cases not to publicly disclose your intellectual property before filing. And one of the ways that you can do this or manage a trade secret is with a non-disclosure agreement or an NDA. And this helps you maintain confidentiality if you need to share any sensitive information with other people.
Thanks, Keeley. Trade secrets are so important to know about and to understand. And I guess, to another pun, I'm on fire here, is that they can protect the secret source of your business. We do have a template or a non-disclosure agreement generator on our website. We'll pop the link to that in the show notes, but our listener, you might like to hop on, have a look at that, and it'll give you an idea of what a confidentiality agreement looks like. A couple of other things about that is trade secrets or NDAs are very applicable before you launch your product. If you want to collaborate with someone else and you don't want to be sharing information with people who might leak it, so make sure that you have that protected. And actually, we're going to talk a little bit more about that later. But one of the things we also want our listeners to understand is that it probably isn't about just choosing one IP right to protect your competitive advantage. It's likely that you will have a collection of different types of rights, such as a trademark to protect your brand or your logo, and a patent to protect an invention that you may have, or a design right to protect a fabulous new shoe style that you might have invented. So understanding the different rights and how they work together to maximise the safeguarding of your intellectual property is really important. So I've talking too much. So having said that, Keeley, what are some of the benefits of having intellectual IP rights for a business?
Yeah, I love talking about the benefits and all the good stuff. So when you register your IP, you're basically putting yourself in the driver's seat. So you get to decide who gets to use your idea and how it's used. So excellent for all our control freaks out there. It's a way to protect your work from being copied or misrepresented as those of a competitor. Plus, having that exclusive right means that you can license it, sell it, promote it, or develop it without direct competition for a set period of time in Australia. And that's a huge leg up. It really gives you control over how your idea comes to life and eventually reaches the market.
That's great, Keeley, and I'd love to build on that, actually. IP rights are not only relevant after you've gone out to market, it's actually a useful tool from the outset of your business. For example, you can actually use a patent in a multitude of ways, depending on what works best for your business or your idea. A patent can provide you with the ability to control how, when, and who can use your idea or invention throughout its life, whether that's during development, manufacturing, or even when you're getting ready to take it into the market. So it's really important to think about how you progress through the life cycle of your idea or your innovation. I think it's important to touch on the point that the earlier you start thinking, preparing and using your IP, the more effective it is for your business. So, for example, you can use an IP right as a negotiating tool if you're a startup, for example, looking for investors, or established brands looking to expand your market share into other countries, for example, by licensing your product. It's important to note, though, that registering your IP in Australia provides you with protection within Australia only. If you're looking at an overseas market, you will need to consider the requirements within that particular country or jurisdiction. This is because the rules, regulations, and registration requirements can vary from country to country. And similarly, if you have a brand or logo that you have trademarked, you can use it to franchise your brand or license it out like you can, with a patent. But similarly, that question around jurisdiction applies.
Yeah, thanks, Nabil, and thanks, Keeley. They're great benefits. And that overseas or international expansion, that's really important for your business, for our listeners to consider as part of your business plan. If you do intend on trading internationally, not only do you need to check that you've got your own IP rights registered in those overseas jurisdictions, but also to make sure that you're not infringing on someone else's IP that's already registered in that space. So it's an important thing to consider. But I'd really like our listeners to hear a little bit more about the benefits of IP rights ownership, and then we might have a bit of a chat about the risks.
IP rights are really an intangible asset for businesses and can enhance your business's survivability, market resilience, and overall value. So we've, over the years, published analyses of business data in our IP reports, which show that startups that file IP in their first year are twice as likely to experience high growth. Patents and trademarks can increase investors' estimates of a startup's value by around 20%, especially in those early development and financing rounds. Holding IP rights can also increase the resilience of exporters to shocks in the global market, such as exchange rates and tariffs. And after filing an IP right, Australian small businesses are 16% more likely to experience high employment growth than their peers without recent filings.
Wow, that's some amazing research, isn't it? Important to note, though, that there's no causality. It's not like go and get a trademark and this is how it will happen. It's that these are some of the consequences of businesses that have IP rights and what happens. But all of the research is available on our website. We really encourage you to hop in and have a look at that just so you can understand exactly what we're talking about. And I really encourage the listeners to have a look at the Scoot Boot and Blue Glass case studies on our website, because both of these businesses have really strong IP portfolios, and they've been incredibly generous in sharing their journey with us. Not only are they great stories about small business ownership and growth and how to scale, they're also great lessons and examples of strong IP management. Now, Nabil, what are some of the potential risks a business might face if it chooses not to secure IP rights for its inventions or designs or trademarks?
So I think with any good business, you should be aware of both the benefits and the risks before you make a decision. In regards to the risks around IP rights, failing to secure an IP right can sometimes mean others might copy your branding, your products, or your services. This can hurt your business by loss of that competitive advantage, that you work so hard for, reduction in your market share, and loss of potential investment opportunities. On the other hand, though, if you accidentally use someone else's protected IP without actually doing your due diligence, your research, you could face significant problems like having to rebrand, destroy your stock, or even face legal issues.
Oh, gosh. So it sounds like we're talking about a couple of different risks there. So correct me if I haven't got the right end of the stick here, but the first one is not having protections of your own IP with registered rights, and then you don't have the mechanisms of the IP legislation and system to protect it. But then secondly, the other risk that you've highlighted is if you haven't checked or done your due diligence, you might find that you're infringing on someone else's registered IP and find yourself on the end of a cease and desist letter or something similar, and then you might have to, pull your product from market or rebrand.
I might actually just jump in here from a personal perspective, because as a small business owner previously, I didn't have a registered trademark for my business. In fact, I didn't actually know very much about intellectual property at all. But knowing what I do now, after being a trademark examiner and educator, I would have gone about that process so differently.
Yeah.
Whilst I might not have needed a registered trademark at the time, I really could have used things like TM Checker, which is a tool for checking trademark availability, and also doing my research to make sure that I wasn't putting myself at risk. Because like Nabil said earlier, there is that kind of accidental infringement or being too similar to someone else already in the marketplace and stepping on their toes that can kind of get you in trouble. I think your brand is how your customer identifies your good or your service. It's around us every day. It's how you choose your toilet paper or your favorite shirt or your favorite pair of shoes. And I think for a lot of us, for a lot of small business owners, this is probably the element that you have agonized over. You've poured your absolute heart and soul into it. So you really want to make sure that you can use it, rather than having to change or pivot or rebrand even.
Oh, Keeley, thanks so much for sharing that story, because that's such a great illustration of why we're doing this podcast and why we do all the work that we do. That TM Checker tool that you mentioned, it's a free tool, as all of our resources and education materials are. Of course, you can hop in there and have a little bit of a play. It's got a combination of questions to find out if your trademark is eligible for registration, and also there's some educational information in there that can help you find your way through.
I really like the passion that Keeley communicated around her business, and that is why it's so important that we educate businesses, to do that due diligence. That due diligence is really critical with respect to your IP, as it will help set the foundations for your business in the longer term. A business could be in a position to negotiate license to sell. They might not have to rebrand. They might not have to do it at their own cost. Again, largely theoretical, but it's a risk. And it's really about, knowing the benefits, knowing the risks, and making that decision.
Great. So there's that really great illustration of the IP right being an asset of your business that you have control over. Well, thanks, Nabil. Sorry, I interrupted you there.
No, not at all. And I think you made that really critical point that it's a really valuable mechanism for maintaining control over your innovation, protecting your market position, and attracting that investment, as we were talking about. Without it, businesses risk losing that competitive advantage that we keep going back to and facing potentially those significant financial and potentially legal challenges.
So, Nabil, while I've got you, I know many of our listeners are probably at the beginning of their journey and thinking about how they will take their innovation to market. And as we mentioned a bit earlier, this will probably involve collaboration with other businesses, whether it be through, market research or supply chain management or whatever. How can our listeners manage and protect their IP during a collaboration?
That's a great question, and something not many businesses are often aware of. It's really important to actually plan out that approach to collaboration to avoid putting your IP at risk. When you're partnering with another organization, it's really important to think about, are you transferring technology? Are you co-developing something? Are you bouncing ideas around? Because this can actually have implications on the IP that you're sharing, that you're discussing, that's being handled. And you really need to think about how you can put safeguards around that. Without a clear plan, things can get really tricky. You might run into disagreements about who owns what, or worse, accidentally give away control of your IP simply by sharing it without those right legal protections. That's where something like a non-disclosure agreement or an NDA comes in. It can help ensure that everyone's on the same page around those protections around that idea, and your ideas stay protected. You can find an NDA contract generator tool on our website. If you consider your business more broadly, though, whether you're working with investors, suppliers, manufacturers, or even your own staff, you want to be clear around what IP already exists, what is being created as you go, and how it will be used. It's all about knowing who has access to what and how it can be used so there are no surprises later.
Now, forgive me, but it does sound a little bit like a marriage. So you're bringing two sets of two parties together, and you need to make sure things are put in place so that if there's a divorce, you know who gets what.
Yeah, it's basically a business prenup.
Business prenup. Love it. Thank you. Okay, great. I guess the next question our listener will probably want answered is, when should they consider applying for an IP right?
I think the answer here is as early as possible.
Great.
Start thinking about it. Because if you've created something unique, a product, a service, a brand, even a creative work, you should think about protecting it as soon as you've created it. And I think doing this early really helps you avoid problems down the track. So identifying your IP and figuring out the best way to stop others from copying it or using it is a big part of growing your business. It's really smart to make intellectual property part of that overall business and go-to-market strategy, because that supports the growth and success of your business. And as Nabil mentioned earlier, and I think we talked about this quite a bit actually, the startups with registered IP are much more likely to attract that early stage funding because the investors recognise the value of protected intellectual property and that asset that you have.
Thanks, Keeley. I think probably if we just reinforce that, if an investor is going to put money into an organisation, trusting that the intellectual property or the competitive advantage that that organisation has is protected by registered IP rights, then there's far less likelihood of that organisation's idea being copied in the market and the investor losing their money because they've not invested in something unique.
Yeah, it's that kind of, that's additional peace of mind, right?
Exactly.
For you and for them.
And for them. That's great.
I want to jump in. We often talk about investors talking about what's your business's moat, that protection. IP is that moat. It protects you.
Okay. Yeah, castle moat.
Castle moat.
Yeah, got it. Right. That's very cool. Now, Keeley, the IP rights all have, the 4 registered IP rights, they have different conditions and different periods of protection, don't they?
Yeah. I'm just going to go into a little bit of detail here because It's worth noting there's different rules for different IP rights when it comes to the length of protection and also disclosure or keeping it a secret. A patent provides protection for a maximum of 20 years or up to 25 years for a pharmaceutical patent. Design rights offer protection for an initial period of 5 years, but that can be extended for a further 5 years upon renewing, so total maximum of 10 years of protection there. And both of these ones, patents and designs, they need to be kept a secret before filing. Now for trademarks, the protection lasts initially for 10 years, but it can actually be renewed indefinitely if you so choose. And our PBR protection, or plant breeders' rights protection, lasts up to 25 years for certain vines and for trees, and up to 20 years for other species. And if I just touch on trademarks, because I think this is really fun, your trademark can outlive you. So the very first trademark, PEPS, was actually registered in 1906. So that's about 120 years old now. And that was for pastils to treat coughs and colds and indigestion. And it actually only lapsed last year once it wasn't renewed.
Wow. Just want to circle back on that secret and not secret, because I know that's something important for our listeners to understand. So if you want to apply for a patent or for a design right, you need to have kept the idea a secret prior to filing your application.
Yep, that's right.
However, if you are applying for a trademark, secrecy is not necessary, but we do encourage people to apply as soon as possible. Look, there's so much more technical information we could share, but we shan't in this episode. But we will talk about trademarks more in episode 2 and then patents in episode 3 and 4. So for our listeners, please do listen if you're interested in those. Now, can we just have a quick chat before we finish about what our listeners should do if someone infringes on their IP, so uses their IP without their permission? And what's the difference in managing that if you own a registered IP right compared to if you don't? And what's IP Australia's role in enforcing?
So in terms of infringement of IP protected by a registered IP right, the 4 registered IP rights we were talking about earlier, like any asset, we talked about these registered IP rights being intangible asset. It's up to the owner to manage it, basically. The legislative framework supports owners in this regard. The rules and regulations and the laws are there. But if you're interested in terms of, the options for enforcement, please look at our website. There's, a lot of different mechanisms for the different IP rights. I think if there were some really key principles, in general, you should be monitoring the market to check if anyone is infringing on your IP and letting them know if you have the registered right and associated protections. Without enforcement, even registered IP can be diluted and misused, potentially harming your brand, reputation, or competitive advantage. There are different ways you can do this, and we have a lot of information available on our website. It's really important and a really good idea to actually include that enforcement plan when you are building your business and IP strategy.
Yeah, that's a really good point, actually, considering that in the whole kind of life cycle of your business and in your business strategy, thinking about, managing your IP rights when you have them as well.
I'll also just note there that IP Australia is a regulatory body. We are not an enforcement body. So we manage the registration of the IP system, but it's up to the owner of the IP right to monitor the market and to enforce their IP right against any infringement out there. Well, look, we have covered so much today, and I think we better wrap up or we'll be running well out of time. I'm just going to give you both a last opportunity to leave something with the listeners today that you think they should take with them on their journey to protecting their IP. And let's start with you, Keeley.
I think when it comes down to it, my big piece is think about it early. A really good starting point, as we said, is that choosing the right IP tool on our website. Mm-hmm. And this is great if you're unsure about intellectual property, the types that you might have, and what registered IP rights that you might need. Our TM Checker tool as well on our website helps you to check if a trademark is suitable for registration. And I think, these are all the resources and tools that I wish I had when I was starting out. They're the things I'm going to recommend because we have search tools for all the IP rights. You can look at what's already out there, what's protected. And these are all, of course, just a starting point to help you understand intellectual property and get started. But like I said, this is all the stuff I wish I knew.
Thank you, Keeley. Nabil, what tips do you want to leave with our listeners today?
I'll just reinforce what Keeley said. Do your reading, do your research. Take a bit of time now because it'll help you and save you much more effort in the future. One other point I'd like to make, if you're looking for advice and guidance specific to your circumstances, you could consult with an IP professional. It's a great way to find attorneys in your area is to visit the Trans-Tasman IP Attorneys Board website, TTIPAB, where you can find a list of IP attorneys and their contact details to start engaging with one.
That's fantastic. Thank you. Look, we hope that today's session has provided you with information and great access to resources that will help you make well-informed decisions about your innovations, your ideas, your business, when it comes to protecting your intellectual property and maintaining your competitive advantage. A big thank you to you, Keeley and Nabil. It's been a delight chatting with you. I'll have you back anytime. So thank you.
Likewise, Lisa. I've really enjoyed it.
Thank you so much for having us. It's been wonderful.
It's a pleasure. And to you, the listeners, thank you so much for joining us. Gosh, that was a great chat. And I hope that's given our listeners some really useful takeaways for their businesses. Just a quick note, the content shared in the podcast isn't intended to be taken as legal, business or other professional advice.